Good morning. Welcome to Netgen Webinar 2018-5. Today we are celebrating the GDPR enforceability, but we are still dazed and confused. So I will try to explain how I'm dazed and confused, and maybe you will share my opinion. Thanks for joining. I'm Ivo. And just briefly to get the context, a few information about me. So I'm co-founder of Netgen. It's a web agency in Croatia. We have a lot of experience in building complex content-centric web solutions. That's why we are, of course, very interested in the GDPR, not just because of our websites and our company, but also for our clients. We also provide technology for other web agencies. It's a lot of it. It's open source, and you can check on our website what we do. Okay, so that's just to learn who am I. Of course, there's a big disclaimer. Given that the GDPR is only active for a couple of hours, I'm not a GDPR expert. Actually, nobody is yet. I would say that we will need at least half a year, or maybe a year, to get some practice, some best practices, some experience, maybe some cases and fines, and then we will know a bit more about GDPR. So far, it's still just a huge amount of legal text that we need to tackle. I'm basically just sharing what I learned so far, trying to find some sense in all this in a couple of last months, or actually from beginning of this year. I'm trying to figure out what is what, and trying to deduct what should we do and what should we advise to our clients. Yeah, dazed and confused. That's mostly what we are now, and we are not the only ones. I'm following a lot of discussions lately on Facebook groups, on LinkedIn groups, on Twitter, on everywhere, basically on Slack channels, etc., about GDPR. There's a lot of discussion, a lot of vague things, a lot of different interpretations, and you basically are dazed and confused if you join these discussion and if you try to figure out what to do. So the dazed, yeah, I'm dazed mostly because there's a lot of legal text. The GDPR is not a technical document. It's definitely not something that talks about how you implement things. There might be some examples in it. I didn't read it all because there are some parts that are not applicable to our use case. So it talks about public institutions or something like that. I didn't go into that part, but I did read all the important things or all the important recitals and parts that impacts, let's say, a standard web industry. And there is not so many technical mentions in there, actually, very few. If they speak about IP address, they mention an IP address as an example for personal data. They also mention at one place, they mention cookies, but not cookies per se. They mention cookie identifiers, which is quite different. So it's not a technical document, it's a EU regulation, and it overrides or related laws from other EU members. There is 28 EU members still, until Britain leaves. So it overrides those local laws. It tries to make, or let's say, equalize the practice and the regulation across EU. What is, in my opinion, it also affects the world in much larger scale, and I will explain why. So first of all, as I understood it, the data subjects or the people that are impacted by EU regulation are EU citizens, but I think it's also goes beyond EU citizens. The fact is that you can file a complaint to a GDPR regulator body in every EU member if you can officially do it. So it's either by EU citizens, or it could be as well some people that have working permits in EU. Maybe they are temporarily in the EU and they have some status in the EU. So it goes beyond EU citizenship, as far as I understood it. That's on one side. On the other side, it also affects companies outside of EU. Not all of them, because EU can try to enforce the same regulation across the whole world, but in practice they cannot fine or punish any company that doesn't have any entity into EU. So if a company from Australia has no subsidiary in EU, it's basically, EU cannot enforce anything on that company. But as soon as a company has a subsidiary in EU, then it might be enforceable. So it affects a lot of global corporations because they have most probably they have subsidiaries in EU. I think it's 88 pages long, so it's a bit dazing. So a lot of legal text, which is not something that a regular or common user could understand. So let's try to summarize this and what I learned or what I understand about GDPR in just briefly couple of slides. So for me, the main kind of main GDPR intent is to enforce privacy and security by design. That's for me, it's quite obvious. And a lot of these things, or the privacy and security by design, companies are already doing. Maybe not of course it depends on the scale. Big corporations have different levels of privacy and security compared to SMBs and things like that. But it's trying to enforce that companies do think about privacy and security. So if you think about privacy, just a couple of examples. So first of all, GDPR says that you should minimize your personal data sets, which is something that is common sense to me. You should also check for data leaks because data tends to leak all over the place, and you should at least be aware of it. You should think about to whom you send it. If you send it to third parties, you should check if they are also GDPR compliant and make an agreement with them so that your relationship is kind of regulated. Of course, it would be good if you can reduce the access to the data. So in terms of development agencies, one could implement something like anonymization of data on non-production instances, for example. And then GDPR talks about retention. So how long can you keep the data? This privacy with design says that you should set up some retention scripts. And then you should, of course, think about what you can or cannot delete. So mark data which can or cannot be anonymized or deleted. Reduce access to personal data only to staff member that needs the access. That's, of course, something that is more important for bigger corporations. It's very hard to do it in small companies where more or less everybody has access to everything. Give users options, that they can, that they are empowered to do what they can do with their own data. And you should, of course, try to detect data breaches. And with GDPR, it also says you should report it, even in under 72 hours. So security by design. So if you talk about privacy, one of the main concerns again, or consequential, is talking about security. So from a web development or web agency, it's kind of a lot of things you're probably already doing. So you want to enforce security standards and best practices. For example, you should update your systems regularly so that they are more secure. You should secure access to data. So use password managers, SSH keys, two-factor authentication, reject common passwords, require hard to break passwords, etc. So there's a lot of these things that, you know, some of this is, you already do this. And of course, encrypt the data, although GDPR doesn't doesn't enforce you need to encrypt the data, but you should think about it, and you should at least encrypt it in transit. So when you transfer the data, you should at least encrypt it then. So this is when we talk about like industry best practices. And with GDPR, one of the things is that you should try to at least be aware of it. You should kind of explain it in internal documents, on some things in public documents, and saying this is what we do to secure the data. So that was just a couple of things that I wanted to say about GDPR and what's the main kind of impact it will have. I will not go into GDPR, the user rights, the what are consents, etc. There's a lot of other resources on the web about it. I would even say there is too many. There's a lot of articles and blog posts and other materials that have a lot of misleading information. They interpret things in very different ways. So this is all making us confused. On top of the fact that the GDPR text is non-technical, it's legal. There's some examples in it, but it's very hard to deduct what the authors wanted to say. There is some kind of, let's say, intention or the spirit of intention, which I described, so that GDPR wants to enforce us to be more cautious about data. But when we speak about implementing things, a lot of things are still confusing. So I will try to explain what is confusing for me. So one of the first things that I see there when following the discussions on the internet is I think there's a big confusion between GDPR as a regulation and the upcoming e-privacy regulation. So as far as I know, the plan was to release both of these regulations at the same time, basically today. But this e-privacy regulation is postponed till next year. So what's the difference? So GDPR talks about personal data. That's it. E-privacy is something that should replace the so-called cookie law. So it talks about cookies and the internet privacy in general, but a lot about it is about cookies. So this doesn't mean, so let's just talk about cookies. So for example, GDPR regulates personal data. It doesn't mention cookies. So I followed a lot of discussions, but I just cannot find anything related to cookies itself in GDPR. The e-privacy will regulate cookies, among other things, but it's still not enforceable. What there is a connection, or there is a possible connection, if you store personal data in cookies. So that's a kind of the only connection between GDPR and cookies. Or if you use plugins that do so. So, for example, if you are saving in cookies something like is a menu and shown or not shown, some kind of user preference, then I don't think we don't need to ask the user anything about it, because it's not personal data. You should maybe set this in the privacy policies, but it's something that it's not something that GDPR should regulate. Maybe the e-privacy regulation will regulate that, but at this point, I don't think we need to worry about this. For example, the session ID that needs to be stored in the cookie is, again, it's pseudo anonymized personal data that you need to store into cookies to have the website function, because otherwise it will not function. So again, if you say this in the privacy policies, I don't think it's an issue if you have this. You don't need to ask the user if you can save it to the cookie, at least not according to GDPR. For the e-privacy regulation, we will see about that. Today, the topic is GDPR. Another confusion, the data controller versus data processor. So there's a lot of, again, talks about it. Sometimes the distinction is clear. So if you have a website, then you are the data controller of the website, and if you send some data from the website to, for example, to MailChimp as a newsletter service, then the MailChimp is data processor. That's relatively simple. But then it starts to get blurry in some cases. So, for example, if you use Facebook, let's say like buttons or Facebook Pixel or something like that, and you embed it on your website, but you don't send any data to Facebook, in that case, Facebook is the controller, and you are kind of a processor because you process the data which is used by Facebook to follow and profile the user. But if you connect your users or your user data to the Facebook user data, which is could be done via Facebook features like custom audience or leads and things like that, then you become the data controller and Facebook becomes the data processor in that use case. And then you need to ask for consent for the user, because the controller's responsibility is to ask for consent. Of course, the data controller is responsible for managing the personal data, meaning that he needs to explain the user rights and provide all the user tools to the user. He needs to ask for consent if there is no other legal ground. He needs to report breaches. He is the most responsible person or the most responsible entity for that data. For example, on our website, we have we have a contact form, and people can contact us, and we store this data. So we are responsible for that. But if we send an email via some from our website as an email notification or a newsletter, then a service that we use that actually sends the emails is our data processor. And the data processor is also responsible. It should be GDPR compliant as well. And he needs to process the data in a way how data controller defined it. And in the case of a data breach, the regulatory bodies will try to find out who is the most responsible. The data controller is always the responsible, but in the case if the breach was caused by the data processor, then the data processor is responsible as well. So then you have kind of a divided responsibility. So that's about controller and processor. As I said, a lot of use cases are blurry and vague because it's a bit hard to understand what is a data controller and what is a data processor. Okay. And then again, a huge confusion is also being in discussion about personal data or personal identifiable information and sensitive data. A lot of people mix it, and in GDPR it's relatively divided or defined differently. So it's about identity. So personal data is any data or combination that can identify a person. So my name and surname is quite a good identification of me. For example, my country is not, let's say, personal data per se. But if I combine my name and my country name, then I'm even more identifiable. So sometimes it's a combination. One could argue that the IP address is not a personal data. Maybe, or it's definitely is if you combine it with time or timestamp. But in the GDPR, it says as an example that IP address is personal data, and this is purely, I think, coming from the practice of the telecom industry. Because if you have, for example, your mobile phone, the smartphone, and you use 3G or 4G, you usually have the same IP address for at least a month or something like that. So an IP address is basically a good identification of a person. So this is like personal data. And then we have sensitive data, which is anything which can be used to profile a user based on some intangible things. So it's not about in what address you live in or which town you live in, but it's more like about the views of the user. So it's about religion, politics, philosophy, health data, and things like that. So this is sensitive data, which by itself, sensitive data doesn't have to be identifiable, or it cannot identify a person, but in the combination with the personal data, then you can really profile a specific user. And that's quite important for GDPR. I will mention it later. So, last thing that I wanted to mention as a big confusion, and this is probably the most confusing thing to me still, is the consent versus explicit consent. And I'll explain why is this confusing. So first of all, let's try to say what a consent is according to GDPR. So what is the difference between those two? So consent is needed if one of the other legal grounds are not applicable. So some data you need to have because of the law, because you have a legitimate interest, or there is a contract, or there is a public interest, or whatever. So if there is no legal ground like that, and you need some data, then you need to ask the user for consent. The consent needs to be revocable. It needs to be verifiable, and that's a bit hard because sometimes you are very hard to log or to store this consent so that you can verify. For example, if you store the consent in a browser local storage, you actually don't have access to it. It's on the user machine. So then in that case, consent is not verifiable, and that's a bit difficult. You know, user can argue that, or user could try to mislead you, and you cannot verify because you don't have that data. And then we have one more thing that everybody at least tries to avoid in discussions, is that children cannot give consent. So the parents or the people that take care of kids, legal guardians, they need to give consent to kids. And how to make this happen on the website, it's quite, let's say vague, to put it mildly. So consent, there are four important kind of features of consent. It must be freely given, so you cannot condition a consent, it must be free. It must be informed in terms, so it means that everything needs to be clearly stated in plain language and visible. So you cannot mislead the user. It needs to be very clear on what the user gives the consent. It must be given for a specific purpose. So if you have several purposes that you want to use the data for, you need to have several consents for that. And that's again a bit of confusing part is it is given via a positive or affirmative act. And that's more or less that you have in GDPR. It says it needs to be given via a positive or affirmative act, but there is no explanation or more detailed explanation of what it means, positive or affirmative act. You can imagine it could be just one click. Maybe it's opening a link, maybe it's clicking on a button, maybe it's a signature, maybe it's, there's a lot of explanation how you can implement this. So this is what GDPR talks about, the consent in general. So what then they do, they mention in 3 cases that a user needs to give an explicit consent. And these are the 3 use cases. So if the data is transferred to third countries, if the sensitive data, this is what I mentioned before, if the sensitive data is processed and the user is profiled based on the sensitive data, and if there is an automatic decision-making with significant effects on a data subject. So GDPR text mentions that in these 3 cases, the user needs to give an explicit consent. But the problem is that what is explicit, what's the difference between explicit consent and a consent given via a positive affirmative act? I'm still very confused about that. So just to give a couple of examples, so if data is transferred to third countries, if you send some data to whatever service provider outside of EU, you might think about this, for example, things like Google or companies like Google or Facebook. What I also tried to find is, does this apply, this rule applies to Google or Facebook, because they are obviously US companies. The thing is that there is a US-EU Privacy Shield regulation. This is a mutual regulation or a kind of a joint effort between EU and US, so that the US companies are actually certified to manage the private data for EU citizens. So I tried to find an answer. Does this rule then for explicit consent excludes those companies that are under Privacy Shield? I didn't still find a clear answer to that. So it might be that because you are sending some data to Facebook or Google that you need an explicit consent from a user. When we talk about sensitive data, it could, of course, you can profile the user by yourself. But as soon as you, for example, in Google Analytics, if you enable demographics feature, or if you connect your users to Facebook user and then start retargeting and things like that, I would say it's you process, or Facebook and Google process the sensitive data about the user for you. And it is sensitive data because Facebook and Google know a lot about the users. You are definitely not sure, and it's very high probability that Facebook and Google are using sensitive data to and process it to offer you a service. So in that case, you might need an explicit consent. And the last example is a bit heavy, but the GDPR text gives a good example of, for example, if you go to a bank and you want to have a loan, and then there is an algorithm that decides whether you should get a loan or not. So that's definitely an automatic decision making with significant effects on the other subject. And if you think about some other example, which is very, very less significant, sending automatically maybe some email to a user, some transaction email. If it's for example, if you have a 2 newsletter list and then you choose based on gender to which newsletter you will send a specific information, that's automatic decision making, yes, but it's not with a significant effect on a data subject. So a lot of confusion there. I would say you should go into details of each specific project or use case and try to figure out for yourself or for the client how to approach this. And I hope that these confusions will kind of be resolved along the way when we learn more about the practice of GDPR. Yeah, that's more or less what I wanted to say. So I was really focused on the confusing parts. So the question is, are you still dazed and confused? If you have a question, please do ask, and thank you for listening. Use the chat feature if you want to ask a question, and I will try to answer. If not, we will soon conclude this webinar and record it for later use. So any questions? Let's see, there should be one question. Oh, no, that's just a thank you note. Yeah, any questions still? Are you still dazed and confused? Like me? Yeah, it seems to me that no question at the moment. So it seems that we are still all dazed and confused. Thank you for listening, and good luck with GDPR. Bye.